You might have read or heard about the benefits of establishing trusts in Zimbabwe, but from the suppliers of information, you find that there is a lot of unanswered questions that remain in your mind. The suppliers of information have withheld a lot of information which have left you on the crossroad. You do not know whether you can register a trust or establish a trust because of lack of adequate information. Hello there. If we are meeting for the first time, my name is Urayayi Chikwetu. I am a legal practitioner based in Harare, Zimbabwe. In this video, I am going to share with you fundamental information about trusts in Zimbabwe. The information is going to be shared in a straightforward question and answer format. So I encourage you to watch the whole video so that you can have a full insight of the information about trusts in Zimbabwe. So the first fundamental question that we are supposed to answer is, what is meant by a trust? A trust is an organization that is established where a founder or a settler or the grantor transfers property to a trustee who is legally obligated to manage the property for the benefit of beneficiaries. The trustee does not receive the property for his own sake or in his personal capacity. He or she receives the property in his or her official capacity for the benefit of beneficiaries. Having defined what a trust is, we now move to the next fundamental question, which is, why is a trust attractive? Why all of a sudden everyone in Zimbabwe is talking about trusts? There are a number of benefits that come with the registration of trusts. Number one, a trust is an excellent estate planning tool. You can use a trust to leave inheritance to your loved ones. Then the second benefit or the second attraction for trust is that it is used to minimize tax, like estate tax. Then the third benefit is that a trust can be used to run business. I think you have heard the talk about business trusts. You can actually run a business using a trust. Then another benefit of establishing a trust is that it can help in efficient administration and asset protection. You find that a trust normally is run by experienced persons, and at the same time, a trust is regarded as a separate entity. And if you transfer your properties in a trust, they are protected from the claims by creditors, and also it is protected from matrimonial cases. Then the other benefit of a trust is that it minimizes conflicts, or it reduces conflicts. If you pass away after having transferred all your properties in a trust, whatever you have provided in a trust is going to be followed, and no one is going to challenge the provisions of your trust. And a trust normally operates during your lifetime, and as such, you may actually experience how the trust is being run during your lifetime. So these are some of the benefits of establishing a trust. Then the next important question, after having answered the reason why a trust has become an attractive vehicle is that to do with the requirements for the establishment of a trust. What are the requirements for establishment of a trust? There are a number of requirements that you must meet for you to register a trust, or for the trust deed to be registered in the deeds office. The first requirement is the intention. The founder must have the intention to create a trust. Then the second requirement is that the intention must be couched in a language that creates an obligation. Then the third requirement is that the beneficiaries must be identified with the reasonable certainty. Then the fourth requirement is that the purpose of a trust must also be defined with reasonable certainty. And then finally, the fifth requirement is that the object or the purpose of a trust must be legal or lawful. Other fundamental question, which is question number 4, is about trust, is that what information is required for a trust deed to be lodged. What information must be included in a trust deed? The following is the information that must be included in a trust deed. Number 1, the name and the details of the founder. Number 2, the names and the details of the trustees. And then number 3, the name and the names and the details of the beneficiaries. Then number 4, you also need to include the name of the trust. Then number 5, you need to include the purpose of the trust. These are some of the clauses that you find in a trust deed. Then, having stated the requirements, the attractions, and the information required in a trust, we now move to the next fundamental question, which is, are there other steps that are supposed to be followed after the registration of a trust? Yes, there are some steps that you are supposed to follow. You need now to transfer the properties that has been donated by the founder into the trust. If the founder dies before the transfer of the donated assets, then the Master of High Court will come in and assist to complete the transfer process. As you know, a trust can own, sell, or buy properties. So it is possible that the master can actually help the trust to be able to acquire the properties that have been donated by the founder. Having answered this question, we now move to the next important question, which is who appoints trustees? The first trustees of the trust are nominated and appointed by the founder. Subsequent trustees can be appointed by the trustees following the provisions of the trust deed. Then the next fundamental question that is normally asked about trust is to do with trustees again, which is, do trustees receive remuneration for their services? This question is answered by looking at the provisions of the trust deed. The usual provisions of the trust deed are to the effect that the trustees provide a voluntary service. They will not receive remuneration, but you find that they also provide a provision that if the trustee uses his or her resources for the advancement of the business of the trust, he or she is supposed to be indemnified. So it is up to the founder whether he or she wants the trustees to be remunerated for the services that they offer to the trust. But the usual provisions that are found in practice that the trustees are not paid for their services. Then the next fundamental question about trust is, can a founder lodge the trust deed on his own? A lot of people may have questions as to whether they can easily approach the deeds office and lodge their trust deed on their own. It is not possible for you as a founder to lodge the trust deed on your own. You need to engage a legal practitioner who is a notary public for you to be able to lodge the trust deed. So the notary public, who is a legal practitioner, is supposed to be engaged, and he is the one or she is the one who lodge the trust deed on your behalf. Then another fundamental question about trust is, can a founder be a trustee or a beneficiary? This is also one of the most important questions that is asked by those who have some idea about trust, and they have questions on whether to establish a trust, and this is one of the questions that may be holding them from registering their trust. Yes, a founder can be a beneficiary and a trustee at the same time. There is no law that stops or that prevents a founder to be a trustee or a beneficiary of a trust. So it is very possible for you to occupy those positions at the same time. Then we move on to discuss the next fundamental question, which is, how long does it take for a trust to be registered? This is a very important question. To register a trust, it takes a couple of days. There may be some delays here and there, but because of the ease of doing business mantra, you'll find that the deeds office is actually expediting some of the processes so that the registration of trust is done within some few days without too much delay. So yes, we may experience some delays, but the government office that have got the authority to register trust is aware that there is need for advancing the ease of doing business mantra, which is the philosophy of our government at the moment. Then the other question is it necessary to write a will when you have registered a trust? My answer is that it will not be necessary for you to register to write a will if you have registered a trust, because a trust is superior as compared to a will. A trust have got a number of advantages as opposed to a will. A will have got some disadvantage in that it can be challenged and declared invalid by a court of law, while it is very difficult to challenge a trust. At the same time, you find that a will is supposed to go through the master process, which is referred to as probate process, which is costly in the sense that you are supposed to pay an executor 5%, and also the master will collect 4% as his or her fees. So while if you register a trust, all those costs are not going to be incurred as a result. Then the last fundamental question is who can dissolve a trust? Yes, we have established the trust, we have registered the trust is running. How can this institution be dissolved? Once again, we look at the provisions of the trust deed. It is the one that give you direction as to what circumstances that bring the trust to an end. You find that some trusts may have some lifespan. Once that lifespan is reached, then it automatically lapses or it is dissolved. Whereas you find that in some trust deeds, the founders may provide that the trust exists in perpetuity, which means they would have created a trust that will outlive generations after generations. They would have created a legacy. So some will create a trust that lasts forever, whereas the others can create a trust that lapses after a certain event happens or after some number of years have lapsed. So there you are. I have set out the meaning of a trust, the requirements for the establishment of a trust, why a trust is attractive, the information you need in order to establish a trust, and also the dissolution of a trust. We encourage you to subscribe to our channel, hit the notification bell so that YouTube can notify you whenever we upload a video like this. Meet you in our next video. Thank you so much.